explain me what is a trademark and why is it so important for a business?
When you register a trademark, it gives you a lot more protection and ease of enforcing your rights because it's governed by the Trademarks Act. A trademark is your brand, so that distinguishes you and your products from other traders. Copyright is more about your creative expression. The biggest benefit of registering a trademark is that it gives you clear, exclusive rights to use your brand or logo in relation to your business under the law.
Welcome to Level Up with Priyanka Shah. Today's guest is Jonathan Williams, an intellectual property lawyer from Art and Commerce Lawyers and Trademark Attorneys. He helps businesses, big and small, protect their brand names, logos, and ideas. From registering a trademark to dealing with legal issues if someone copies your brand, Jonathan makes the legal stuff simple and easy to understand. So if you have a business or looking to start one, this episode is packed with insights you don't want to miss. Thank you so much for coming on the podcast Level Up. So excited to have you today. And it's a topic that as I mentioned, that I don't know much about, and I'm very excited to explore more about trademarks with you through our conversation today.
Great. Well, thanks for having me. I'm really excited to talk to you about it.
My pleasure, Jonathan. Thank you so much. Jonathan, I'll just start with something very basic. Can you explain me what is a trademark and why is it so important for a business?
So a trademark is a sign that distinguishes your business and its goods and services from other traders. And it's important when you're investing in a new business that you protect your brand to stop others from copying it and also give you the opportunity to enforce your rights if something goes wrong.
Sure. So if I talk from my point of view, I've got a business and I've got a logo as part of my business brand and the name and everything. So do I trademark the logo? Is that what is, or the name, or what?
Well, ideally, you would trademark both. And some traders find that from a cash flow point of view, they might do one or the other. Right. And it depends on how distinctive the trademark is and how competitive their market might be as to which they go with. But from sort of a first step, I would say protect the words if possible. But we would always sit down with our clients and see what's most important to them. And if the branding is very strong and very distinctive, it might be better to go for the logo. But generally speaking, the word is more important because it can be used in text as well as on your website or your socials or on the side of your building.
Sure. So with the word, you're meaning the name of the
That's
person.
right, yes.
Sure.
Yeah.
Perfect. Great. Thank you for that. And maybe what are some common misconceptions people have about trademarks, or why again, I talk from my point of view, as people, me and around me, have never spoken about it.
Yeah, it's a great question. Probably the biggest misconception is that a business name or a company name is the same as a registered trademark, because when you register a trademark, it gives you a lot more protection and ease of enforcing your rights because it's governed by the Trademarks Act. A business name, you can register, but someone can still apply for the trademark. Or a company name, for example. So that's probably the number one factor. The second thing is when choosing a brand to be your trademark, some people think it's a good idea to sort of copy something that someone else has done because it's been successful, and that's a big no-no for obvious reasons. It can cause problems where you might face a cease and desist letter or worse, and also you might have to rebrand, which can be very costly and time consuming and is especially tough for founders of new businesses who've just outlaid a big chunk of money to get their business started.
Sure. One thing I often find myself and other people being confused is between trademarks, copyrights and patents. Are they overlapping? Are they similar? Or are they completely different?
Essentially, as we've sort of discussed, a trademark is your brand, so that distinguishes you and your products from other traders. Copyright is more about your creative expression, so it is a right in relation to literature, the written word, artwork, music. It can also cover films and other forms of creative expression. And a patent is more about inventions and, technical innovation that's unique and novel. So that might be a process or a way of doing something. It may also involve, a technical gadget and the way that it works. So they're quite distinct. There is a bit of overlap between copyright and trademarks, because the words in trademarks or the logo might also have copyright, but it's easy to understand why there's some confusion, because intellectual property law can be quite complex and technical. But that's what, as an IP lawyer, I try and help my clients through that process of working out what sort of IP protection they require for their business.
Sure. To simplify, would you say that trademark is more for the business name and the business in particular? It is more for a product.
That's correct. Yeah. So trademark is more about the brand, the words and the logo of the business, whereas patents, generally speaking, is more, their product, their inventions. Sure. Yeah.
Sure. Great. Thank you for sharing that, Jonathan.
That's okay.
Again, at what stage should a business start thinking about a trademark?
Mm-hmm.
Is it at the start, or can they get started and even somewhere down the line think about it?
Ideally, it's worth thinking about it right at the beginning. And I say that because some businesses will have a spark of a great idea and they've got a brand name they've fallen in love with and they're ready to go, and everything just needs to happen now. But getting protection for their brand might be an afterthought, either because they're too busy or they haven't got the funds to allocate at that time. But the risk in doing that is you could potentially be copying a competitor without even knowing it. So we recommend that clients do their due diligence from the outset in doing searches to make sure that their trademark is, number one, available, number two, it's registrable, and three, that there's no infringement risk by using that trademark. So they're sort of the key steps and I guess common mistakes people might do is jump into it without doing their due diligence.
Right. And when you say look into that, if it's available, it's registered, where should someone look into it?
Well, generally speaking, you could do that yourself initially by doing some basic Google searches and checking the trademarks register. But what a trademark attorney or an IP lawyer does is they'll do a clearance search that covers not only registered trademarks, it also looks into domain names, business names, company names, and does what's called a common law search, which is unregistered trademarks that might be used out there in the community and could potentially be a risk, an infringement risk if you use that brand name, that logo or a similar logo without either getting permission or choosing something that's not already in use.
Right, okay, interesting. And I think that's where an expert like yourself comes into the picture, because there's only that much limitation that you could do through Google and things like that. And when you have an expert like yourself who comes in, there's so much more that you could add and check, which provides so much more business and relief to the business in the long run. Yeah,
well, sometimes, unfortunately, we have clients who come to us, and it's quite common, where they've started using a brand name or they've applied for a trademark and they find that they're not allowed to use it because another trader's already using it, or they've had had an error in their application. We can often work with the client to resolve those issues and find a workaround. But in the worst case scenario, they might have to rebrand, which is always a bit of a devastating outcome because they've put a lot of energy and finances into developing that brand. So the best practice is to do the due diligence and engage a professional as early as possible.
Now, have you come across any business who had to rebrand their business?
Yeah, there's been a few along the journey, and it's a difficult conversation, but sometimes business owners find themselves with no alternative but to reset and either come up with a new company name and brand as their trademark, or amend their logo so that it doesn't look like a competitor's mark. But we sit down with our clients and try to find workarounds, and that might include trying to reach a coexistence agreement with another trader to see if they will be accepting of our client using that similar trademark in the marketplace. And it might be they're in a different geographical location in a different state and there's less likelihood of confusion or overlap, or that they work in different industries, and we can sort of work on that basis to find a way that keeps the other trader happy, that our client is not encroaching on their business or their client base. But obviously it's really on a case-by-case basis.
Thank you for sharing that. It brings to mind one of a personal experience, again, not for myself, but a family member who had a shop in India, and it was a kid's shop, but used Mickey as a logo or a picture, like a part of half Mickey face or something. And somehow Disney came to know about it, and they actually filed an infringement notice against them. And their shop was a really small shop in India. And I was like, how did Disney come across it and they filed something against that? And they had to work it out and change it.
Well, trademark owners engage attorney firms to monitor use of their trademarks in commerce and to see if there is any unauthorized use by other parties. And the example you gave, on the one hand, it sounds like it's a bit heavy-handed. On the other hand, if you're the trademark owner, you might think, well, that's reasonable. I've got the right to use my trademark exclusively, or I can license it to other people to use it. So we need to be careful just in everyday circumstances of, if we're doing a fashion shoot for our product, or we're launching, let's say hypothetically, we're launching a new car and we've got a model standing next to the car and they've got a logo T-shirt on it. Say they've got the Nike swoosh symbol. That is effectively trademark infringement because we're creating the impression with our audience that we have the approval or some association with Nike to use their T-shirt brand. So we've got to be careful about those things. And what you've described is not uncommon. We deal with clients on both sides of that equation. And for the small trader, it's definitely a scary proposition of getting a cease and desist letter. They tend to be, proportionate to the type of use. If they're not saying we are Disney or we're associated with Disney, the outcome is probably going to be less problematic, less costly to resolve that. But it's certainly something we have to think about in the way we promote our business, that we have clean shirts, clean logos, and photo shoots, little things like that can make the difference.
This episode is sponsored by Finsol Insurance, where we help families protect what matters most: your health, your loved ones, and your lifestyle. Life is unpredictable, but your financial security shouldn't be. So if you're a parent, a homeowner, or just someone who values peace of mind, make sure that you are protected with the right protection. Use the link below to book a strategy call and take the first step towards securing your future. very interesting because again, like I was thinking, I had a friend who uses the Google Chrome colors or something. Again, I don't know if Google may have trademarked the colors or no, but that could be something that should have been checked beforehand so that it doesn't happen to have problems.
Potentially. I mean, big tech companies and multinational brands use very sophisticated tools to identify potential infringements. They're basically crawling the internet and social media looking for these things. As I mentioned, they tend not to come down so heavily on smaller infringements because it's a waste of their time and resources. But it does happen, and I've certainly seen that in recent times when people do receive cease and desist letters. And, conversely, where our clients are seeing people passing themselves off as being this other trader or creating the impression that they're in some way connected, and they just want to put a stop to that, to stop confusion, but also to stop another business from effectively riding on their coattails.
Makes sense. Sure. Thank you for that. And again, if I had to go into the details of what is the step-by-step process of registering a trademark, can you maybe just briefly guide us through that?
Yeah, as I said, trademark law is quite complex, but I'll keep it high level. Yeah. So the first thing is to do a clearance search and see if the trademark's available, if it's capable of being registered, and if there's any infringement risk in using it. So we do a clearance search. Then the next step is to draft a specification and file the application with IP Australia if it's an Australian trademark, and that will designate the types of goods and services that you're planning to use your trademark for. Then the trademark is examined by the examiners at IP Australia, and you'll receive a response that either says your trademark is accepted and is ready to go through the final stages of the application process, or there's an issue and this particular issue has been raised as a barrier to registration, and you need to be able to respond to the examiner effectively in order for it to proceed, or you might choose to abandon the trademark if it's too hard to overcome those concerns of the examiner.
Okay, and how long does that process typically take?
Well, in an ideal world, in Australia, it takes approximately 7.5 months from application to registration. That's if there's no issues. And that's actually quite good in global terms. If there's an issue, it can take an extra 6 to 12 months. It could take years to get your trademark registered, depending on the complexity of the issues and the strategy that you use to overcome them.
Okay. And that's definitely much longer than what I thought it would have been.
Yeah.
But no, thank you for that. And what are the different types of trademarks? And are there any, how would the business decide what to choose? Or are there any different types of trademarks?
Yeah, so the main types of trademarks that businesses apply for are the words, the name of the brand, or the logo. But there are other types of trademarks such as shapes, sounds, smells even, which, depending on your product and how mature it is in the market and the risk of someone else copying you, you might look into those things. So a sound, for example, could be a catchphrase from an ad, or if you're making and marketing alcohol or perfume, you might have a unique bottle. So you want to protect the shape to stop competitors copying you. But it really depends on the type of product that you've got. But as I said, mostly it's the words and the logos that are applied for.
Sure. So you could have a trademark for your name and your logo, but down the line, if there's something more unique that you bring out, you continue to trademark that as well.
Yeah. As the business becomes more mature and you can continue to innovate, and you can then determine what your risk profile is. You'd sit down with your attorney or IP lawyer and come up with a strategy to make sure that your business assets are adequately protected. And that also has benefits down the track in terms of increasing the value of your business because you've protected those rights.
Sure, okay. And I think it becomes an asset for the company that it does have a trademark and it brings in that intangible asset to it. So
yes,
the valuation could go up because of that.
Yeah, particularly if you're selling a business or trying to invite investment. Investors look at the IP of a company and it does have a value. Registered trademarks can also assist when you're involved in export activity in terms of qualifying for grants. If the business is not doing so well, the trademarks or other intellectual property like patents or designs can be sold to try and recoup some of the losses of the business. And in e-commerce, we're finding that platforms like Amazon, etc., using trademarks as part of the verification process, and that can help profile your product or service higher on their platforms and getting before more customer eyeballs. So it's a great asset in that respect, particularly in the e-commerce space.
Sure, great. Thanks for sharing that. Have you seen any common mistakes that business owners make when it comes to registering for trademarks?
Yes, and without trying to sound like I'm just blowing my own trumpet, it tends to be when people are filing applications themselves rather than using a professional that they make simple mistakes that could be costly, like using the wrong business name, misspelling, or categorizing the goods and services that they're trying to get protection for. Once again, the due diligence and the clearance searches at the front end can save you literally thousands, and make sure you get it right. But they're probably the most obvious things, apart from copying someone else's brand and trying to basically register a trademark that's very similar to a popular brand on the basis that you think it'll attract customers because that other brand is well known. Yeah.
Okay. If I had to go on the other side and understand that what should a business do if they find someone else using their logo or the name or something similar to what their business assets are? Initially,
I think it's good to talk to a lawyer in that regard, because they can work out what the scope of that copying of your brand is and come up with a strategy of how to resolve it as quickly and efficiently as possible. Quite often these matters don't go to court. Engaging a lawyer to draft a cease and desist letter and to serve that on the offending party, and they also will do research on where else they're using your brand without authorization. That tends to stop that type of activity quite quickly, particularly if it's coming on a lawyer's letterhead.
Right. Okay.
However, if that is unsuccessful, then there are further steps that you can take. And the benefit of having a registered trademark is that you can rely on the Trademarks Act, which basically unequivocally confirms that you are the owner of that trademark and you have the right to enforce your rights in that mark. It's more costly and difficult if you have an unregistered trademark. Not to say that it can't be successful, but there's less opportunity to rely on that registration, which more often than not will bring the matter to a close very quickly. Because if that person goes to their lawyer, they'll say, you've got a problem here, you need to stop using it, and you need to agree to remove it from your website, from all your marketing collateral, and agree that you won't infringe the trademark owner's rights again. So we work pragmatically with our clients to get that resolved as quickly as possible and as efficiently as possible without the need to go to court, if possible, because that can be a very time-consuming and costly process. But if someone's ripping off your brand, copying you, we encourage our clients to act quickly and decisively.
Sure. I think it makes sense. And yes, I was talking that this protection is only available if that business had a registered trademark. If they didn't and they still saw someone else using it, there is no respite available to the initial business.
There is, and you can enforce your rights if you have an unregistered trademark, but it's much more difficult. And there can then be the argument in response of, well, we used it first, and there's no kind of way of clearly, concluding that argument quickly without going through a process of exchanging lots of legal letters or going to court and getting a judge to decide. Whereas a registered trademark, the person whose trademark's being infringed can say, I've been registered, my trademark's been registered for my exclusive use since this date. And it's there on the trademarks register for everyone to see. And as I said, more often than not, that can usually bring the matter to an end very quickly. Whereas if you've got an unregistered trademark, whilst it's not impossible, it's a lot more difficult to get a good resolution for the brand owner.
Understand. Thank you for that. And if a business is looking to expand globally, would they have a need to register their trademark in every country they're looking to expand? Yeah.
So trademark registration is by country, not by region. So if you apply in Australia, you've got to and you're successful, you've got a registered trademark within the Commonwealth of Australia. If you want to use it in New Zealand, for example, you need to apply separately in New Zealand. Same with, UK, US, China, wherever.
And as an IP lawyer, you would be able to help with registering in every relevant country that it goes to?
Yes. So there's a few different ways that can be achieved. There's a process called the Madrid Protocol, where you can apply for trademarks in multiple jurisdictions through one application. It's not applicable in all countries in the world, and there are certainly some countries where it's better to apply direct. And what we do is work with our network of professionals in those territories, so IP lawyers or trademark attorneys, to get the best result in terms of, putting through a successful application.
Sure. So it may be a case where a company or a business may not be, it may be local to start with and then goes global, and
exactly.
You can change that at that point and make it register in multiple countries at that point in time rather than from the start itself.
Yes, and you can do that at any time. It's sometimes better if it's done close to the Australian application because you get what's called priority. However, if you have an application on foot or a registered trademark in Australia, you can certainly apply in any international territory.
Okay. Jonathan, are you able to help us? What are the benefits of registering a trademark to a business?
Absolutely. So fundamentally, the biggest benefit of registering a trademark is that it gives you clear, exclusive rights to use your brand or logo in relation to your business under the law. So it gives you a legal right to do that, and that means you can prevent other traders from using a similar brand for similar goods and services. If you find that there's a competitor out there who might be copying your brand or elements of your business, and it's creating confusion in the marketplace, you can basically bring that to a close quite efficiently and decisively. There's also benefits in, as we discussed earlier, about enhancing the value of your business by enhancing brand recognition. It's helpful when you're selling a business because it's a valuable asset of the business, and also in e-commerce of getting your brand profiled on marketplaces such as Amazon, Facebook, etc. So there are some real benefits there for business owners to protect their brand and also use it strategically down the track if there's a business sale or something like that.
Sure, thank you for sharing that. It's given me a lot of insights and things that I'll probably take action and contact you very soon after this so
Great.
that I can make sure that all my business assets remain protected. But before we let you go, Jonathan, I just wanted to pick your brain. If someone's starting a business right now, what tips or advice would you give in terms of registering the trademarks, or where should they start?
Well, the first thing they should do is establish if the brand is available and capable of being registered. So doing clearance searches is the first step, and where possible, engage a professional to help you work through that process and work on a strategy of how you plan to use your brand in relation to your goods and services. And that can avoid complications down the track, and also ensure that the process is as streamlined and cost effective as possible.
Perfect. Yes, I think a lot of our listeners are probably either a business owner themselves or starting a business would derive a lot of value from these valuable insights that you've shared about trademarks and intellectual property. And I will definitely share your details down in the description.
Thank you.
But where could they find you?
Well, the easiest way to find us is to connect with us via our website, www.artcomlaw.au. That's artcomlaw.au. You can book a meeting on the website and we can have a free consultation with you about your business and your trademark needs and take it from there.
Perfect. Awesome. Thank you for sharing that. And I will have all the details down in the description as well. So it's easier for anyone who's interested in getting their trademarks registered to reach out to you straight away.
Thank you, Priyanka.
Thank you for joining us today.
It's been great to chat with you.